Herb Dopdell, Judge Herb Dopdell, and we're going to talk some more today about small claims court. Believe it or not, we can do a lot of things in small claims court that people don't think about. In other words, rescinding contracts. What does the rescinding of a contract mean? It means that the contract is no longer in effect. Each party gives back to the other what it is that they gave as a part of the original contract. So when you talk about the word contract, is there a difference between an oral contract and a written contract? People ask me that question all the time. The answer is not really. The biggest difference, of course, is the manner of proof. When you have a written contract, you've got dialogue. You've got somebody signing something. Something is defined in the document itself. It's a lot easier to prove, unless there's an ambiguity in the contract, in which event, under certain circumstances, other evidence is admissible. Now, that deals with rescission, and that's an available remedy. Specific performance. We can compel people to do things. I have ordered people to accept back a car or furniture because it didn't meet up to the original expectations of the parties. But getting back to the oral and written, an oral contract has a 2-year statute of limitations, meaning you have to file a lawsuit within 2 years of the time of the breach. Breach means the other party didn't perform or performed improperly or otherwise. That's a 2-year statute of limitations. And in an oral agreement, you have to bring in witnesses and evidence to support what happened. It's a step beyond proving a written document. Now, a written contract has a 4-year statute of limitations, meaning you have an additional 2 years to file an action to recover your damages under a written contract than you had when you have an oral agreement. Now, the quickness of the proceeding is helpful. In many lawsuits, it takes years to work your way through the court system. Not in small claims court. Generally, after the trial is heard, everything is done. Appeals are infrequent, although they are possible for a defendant, not for the plaintiff. And so therefore, the defendant can file an appeal, but usually the whole thing is done within 90 days from the time it was originally filed. If you have any questions and you want to know about small claims court, there's a chapter in my book on it, on small claims. The book is called From the Trench to the Bench. Or call me, or write me, or email me at askjudgeherb@gmail.com. I'll try to get back to you. I've been pretty good so far, but we have a little volume and sometimes I get too busy. But I will try. Contact me if you have any questions.